Welcome, everyone. Thank you for joining us today. We have a lot on our plate to talk about concerning workforce reductions. We don't want to have a negative forecast, but we are seeing a lot more activity in just throughout the country, including North Carolina, on companies making some decisions about reductions in force. And then we've also had some changes in the law recently that affect agreements. So we thought this would be a good opportunity to get ahead of that issue for everybody. So today, let me introduce our speakers. My colleague Erin Barker is I would say one of my trusted advisors on all things employment and ERISA and a variety of employment law issues. I'm Beth Langley. I practice with our labor and employment group, and we welcome you all here. Thanks so much for being here. Our topics today, and again, we've got a lot to cover. We're going to talk about voluntary versus involuntary reductions in force. We're also going to talk about WARN Act issues and things to take into consideration, discrimination considerations, because we all want to avoid those claims, age discrimination requirements from the federal age discrimination statute, and an amendment called the Older Workers Benefit Protection Act. We often refer to that as OWBPA. And then, as I mentioned just briefly, what the separation agreements and releases are going to look like going forward. So would like to next Erin take this over, and here we go. We're off.
Thanks, Beth. So as Beth said, I'm Erin Barker. And to start us off, we have our disclaimer that this webinar is general information. We are trying to cover a lot of topics for you all today. And so we are in no way going to get as deep as we could into some of these topics, and nothing we talk about today is legal advice. It's not fact specific to your circumstances, and reductions in force are so fact specific and so specific for each business and each company. Your workforce reduction, if you have one, may look very different from someone else's. And so again, this is not legal advice. And of course, we think that anyone who is considering a workforce reduction should consult with an attorney, because as you'll see, there are a lot of legal issues to consider. So we are not going to be talking about your company today, but we are going to be talking about our fictional company, ABC Inc. So for part of our webinar today, we are going to sort of walk this fictional company through planning a reduction in force. So we have ABC Inc. We are a North Carolina corporation. We manufacture and sell widgets. So ABC Inc. has some sort of different operations in play. It has manufacturing facilities and sales headquarters and offices. Over the last couple of years, there was a dramatic increase in sales. And so ABC Inc. hired several new employees. It now has 100 employees spread out over 4 different states. But unfortunately, ABC Inc. is now looking for ways to cut expenses long term. It's thinking it could probably close one of its plants. As far as the demand for its products go, it's thinking one plant will be enough. And it's also thinking it could look to other ways to reduce its workforce, restructure, increase efficiency, decrease costs, sort of those business necessities that are prompting this consideration.
So let's talk about how ABC Inc. is going to plan this reduction in force. And we specifically use the word planning because this is, if you're going to have a reduction in force, it requires a lot of planning. It's really not something you can just do, turn on a dime ever. There needs to be some careful considerations. So starting with initial considerations, mapping out what's the business reason for the reduction in force. Now, a lot of these are business operational questions, but these are the fact scenarios that, when documented, well, help to defend any potential claim that may be down the road. And so we're always looking at, what do the documents look like? So we think it is important to we do think it is important to actually plan, have and in writing, what are the business reasons? Think ahead of whether or not the best approach is going to be a voluntary severance, self-identifying severance plan, or is this going to be an involuntary reduction in force, or a combination of both? And that's also a good time to start looking at criteria that you're going to use as far as selecting employees who would be subject to a reduction in force. And that is whether or not you go with a voluntary or an involuntary. Do you want a separate severance agreement? Do you want to offer, if so, are you going to have a signed release, which, as attorneys, we're always going to tell you, if you're offering money, offering consideration, get a release. So when we're talking about the reasons for the reduction in force, we always think about what are those legitimate business reasons? Again, this is what you're going to be documenting because it affects a whole bunch of other laws. So is it financial hardship? Is it because the sales are down, there's underperformance in a particular region or a particular type of product or service? Is as a result of market conditions, do you have too much staff, a redundancy in staff? Sometimes these take place as a result of a merger or acquisition that has its own set of issues to check off a list from a legal perspective. Maybe there's plant closures or other sort of external factors. It could be that issues are isolated to one area but not the entire company. One of the things we want to make sure is that your reason is a legitimate non-discriminatory reason and not something that's going to fall into areas where you could end up with legal liability. Things to avoid. You want to, you can't say, I'm going to close this plant because the employees are attempting to unionize, or it's a union shop. That would be a violation of National Labor Relations Act. Similarly, a reason of, oh, we need a younger workforce. That's going to run afoul of the age discrimination, both state and federal statutes.
All right, so taking a look at ABC Inc., you'll see we had built into the description here, and we've highlighted in red the legitimate business reasons that ABC Inc. is considering a reduction in force. We have economic conditions, looking to cut expenses, so there's probably some financial hardship that will be documented. ABC Inc. plans to restructure. It would like to increase efficiency, decrease costs across the board. And so these are the sorts of documented reasons to support a reduction in force that are going to really help move forward with avoiding legal risks and potential legal liabilities. So Beth mentioned that a company may consider doing a voluntary separation program. It may consider doing involuntary terminations or a combination of both. A voluntary separation program is usually where employees are offered the opportunity to voluntarily resign, and in exchange, the company will usually offer them some sort of consideration, usually money. Sometimes it's installment payments, sometimes it's a lump sum, sometimes it's a set number of weeks of pay, other times it's based on years of service. If you've worked here longer, you may have a more attractive package that you're offered. Sometimes we hear it called early retirement or an exit incentive. we wanted to note that the risk with early retirement is if you're offering voluntary severance benefits to older workers and you have age as a criteria for being eligible to sign up to voluntarily resign, you could encounter issues later if you then move into involuntary terminations and continue to use age, or have, there's documented evidence that you were using age as a criteria. So that's just a risk we wanted to flag as far as early retirement goes. Although it can sometimes be attractive, because sometimes, employees who have been there a long time and who may be older may also be some of the higher earners. And so it may seem like a good way to cut costs, but it does come with risks later down the road. But there are some potential reductions in risk. So when you have employees voluntarily resign, oftentimes they may leave on a more positive note than if they're involuntarily terminated. It also sort of helps you to show that you were not selecting these employees. And so depending on the eligibility for the program, you may have a better argument that they weren't selected in a discriminatory way, or that there wasn't a disparate impact on a certain population, which we'll talk more about later in the webinar. Involuntary termination, that's going to be where management selects employees. Sometimes there's a committee that's working on it. Sometimes that committee seeks input from, division managers, especially if it's a larger company. And in involuntary terminations, employers may or may not offer money in exchange for signing a release. They may or may not offer some sort of package. Oftentimes that package is less attractive than it would be in a voluntary program. If you have a voluntary program, you want it to be enticing enough for the employees to sign up to resign. Whereas if they're being terminated, you may be able to cut some costs that way. ABC Inc., for our purposes, has decided to conduct an involuntary program. It has documented that it weighed alternative measures. It looked at whether a voluntary program or just implementing hiring freezes or pay reductions was going to help its business enough. And it determined that the timing of that wouldn't work. It needs to cut costs now. It needs to cut about 1/3 of costs. So it's looking to cut about 1/3 of its workforce. And it has decided that based on demand, it is going to close one of its supply plants and eliminate some other positions in order to get to that 1/3 cut. Now, ABC Inc. is doing an involuntary separation program, so that is going to be our focus. We're going to probably refer to it as a RIF, or a reduction in force. But we wanted to have a note on voluntary separation programs. They are going to be covered by ERISA, so they are going to need proper documentation. Employees have rights as far as claims procedures and knowing about the plan administration. And the employer is going to have responsibilities, potentially including reporting responsibilities, depending on the number of employees who are eligible. We often sort of go through the example process here when we help with voluntary separation programs. We help draft all that documentation to get us started. And then the company moves forward with notifying the eligible employees, distributing the materials, letting the employees self-select to voluntarily resign. The company then determines whether it's going to accept that resignation, or maybe someone who the company has determined is too essential of an employee. They don't accept that self-selection. The companies notify the employees that they're selected. They distribute those separation agreements, and then allow sufficient time for employees to consider sign and return. So as you can see, this is a long process, not necessarily months, but it does take time to plan and time to ensure that all the documentation is correct.
Thanks, Erin. I want to make one more comment on the voluntary severance programs because they're covered by ERISA. ERISA has some really strict provisions on how long you can have one of these in place. So what we would caution is that if your company has conducted a voluntary severance program in the past, don't just kind of cut and paste those documents and go again, because we would need to make sure that you're in compliance with ERISA. Excuse me. And so you can't just keep going over and over and over again doing the VSO. Each one needs to be customized.
Yeah, thanks, Beth. And it's the tax code comes into play there too, because if it's a pattern and practice of these voluntary programs, then there could be some serious tax consequences for those severance packages that are offered.
Thanks, Erin. So we're going to move over and talk about involuntary termination, since ABC Inc. is looking at involuntaries, and often, even if there is a voluntary, there is an involuntary component afterward. So let's kind of talk through how you would go about that. First thing is setting out the criteria for selection. A lot of clients I talk with, we talk about making a super mega spreadsheet that has all of the criteria, and that's got all of the objective data that will be related to that criteria. So for instance, there could be a seniority component, last in, first out. There are often, sometimes you've got single position elimination, sometimes you've got single function elimination. So you want to look at those and make sure that in doing those, you're not, adversely. And we'll talk about doing the risk analysis and statistical analysis. One thing also is to think about terminology. There is a difference between a layoff and a reduction in force. Typically, when you use the word layoff, you're talking about a furlough where the employment relationship is continuing. There's a possibility they may end up being terminated, or they very well may be called back. So that's more when you're using language. Layoff is more of that temporary, may still be brought back. Reduction in force would be, employment ends because of a workforce reduction. Some other things to think about as far as that criteria is performance or employee skill sets. Maybe there's your organization is in a great deal of transition. You're trying to address AI and a whole bunch of other external factors. So other skill sets are required. Think about how that documentation looks. One of the things we often run into is, okay, we're making decisions based on performance or skill sets, but managers who a lot of folks are just conflict avoidance and avoidance. So the performance evaluations are all looking, you got people you want to select, their performance evaluation is outstanding or exceeds expectations. So make sure that if there is a skill set issue, but you've got someone who from your internal documentation that someone else is going to be looking at, if there is a suit, would say this person's doing a great job. Be able to document specifically what is that skill set. Has something changed? Has the market changed? And another kind of advice is try not to use code words like not a good fit or can't get up to speed, because that's often code for discrimination, particularly race discrimination. Not using words that would imply age discrimination. So those are things to sort of keep in mind. Also, if there's, look at the distinction of, is there a department, a subdivision, an entire location that is being closed, that's going to be viewed differently than if you're doing just general reductions throughout the organization. Some other planning considerations. A lot of times, you all deal with this more than we do on the front lines, but it's, there's a mandate from the top of we've got to reduce costs in our, human resources employees by 20%. So you've got a percentage, and then you're working down from that. Think about that. Also budget in legal fees for getting the documents prepared, the cost of, what the impact is going to be on your unemployment account, the SUDA and FUDA, and also the cost of any severance packages. So all of those should be kind of factored in what you're looking at as far as budgeting for this reduction in force. Other things to keep in mind: what's the impact on temporary, seasonal, or contract workers? We often see if employers are making a shift and say, okay, I'm laying off my regular full-time employees, but I'm going to replace them with temporary workers. That often would, that gets the attention of our state and federal regulators. And so they often are saying, whoa, wait a minute, those folks, if you're trying to convert to temporary or contractors, may very well be misclassified. So be alert to that. Think about transition plans. And one other key point is it's just be aware that if you're going to go through a reduction in force, seek severance agreements with releases from everyone, then there needs to be a hiring freeze for a substantial period of time. So at least 6 to 8 months later, that you're not adding new positions, absent some really unforeseen situation. But that could be a factor in which the EEOC in particular in courts would find that the severance agreements were entered into fraudulently. So just keep that in mind.
Great, thanks, Beth. So back to ABC. We have 100 employees. We're in 4 states. We're doing an involuntary RIF. We are going to close one plant and eliminate some other positions. We want to reduce the workforce by about 1/3. And now ABC needs to consider its selection criteria. So, we're going to close one plant, but then for the other employees who are being reduced, we need to figure out, okay, are we going to do seniority? Are we going to do position elimination? Are we going to base it on performance? And then when ABC takes a look at its breakdown of employees, it has one of those super mega spreadsheets, and it's looking at hire dates and thinking, oh, can we do last in, first out? It realizes, we just recently hired our head of HR and our new head of our accounting department. Those positions needed to be filled, and they're performing these essential functions, possibly even helping sort of restructure the company by taking over those departments. So we don't want to do seniority. So we're going to look at other legitimate reasons or legitimate selection criteria, and consider, okay, we've got a bunch of recently hired employees in one office. There's a bunch of sales positions and 2 managers. We've got the plant down in South Carolina. We've got a bunch of manufacturing roles, some administrative and supervisory roles, and a payroll manager. And then we've got 13 in the Virginia office, all recently hired, 11 sales positions, and 2 regional managers. And so ABC is going to say, okay, we are going to focus on performance and skill set. We took a look at, the Maryland versus the Virginia office, and we have 5 sales positions to 2 regional managers versus 11 sales positions to 2 regional managers. And so we're gonna cut one of those managers out of Maryland based on performance and skill set. In North Carolina, we're going to reduce by 3 positions based on performance and skill set. And we're going to make sure that that performance and skill set information has been documented. And like Beth said, it's going to be based on pre-existing documentation like annual or semi-annual performance reviews, potentially, write-ups and other sort of disciplinary actions that are in that employee's file already. And we are not just going to, look at performance without having this objective documented criteria to support our decisions. And as Beth said, these other planning considerations, we just wanted to, make sure that it's clear that there are legal considerations, and there's also business considerations when you're selecting employees. So, if you are eliminating positions and you want to have a smooth transition and make sure that those duties are being filled, once the RIF is over, or making sure that the people who are being retained, are aware that they're going to have additional job duties, perhaps if someone's position is eliminated and those duties are spread out among others.
Aaron, we have a question from one of our participants about, I guess it's what I said earlier about not, if you're having a hiring freeze, and let's make sure that you're not going to be backfilling these roles. Typically, you're going to look at all of the, which employees are affected and what roles are they in. So let's take the ABC. If, we're eliminating a regional manager, several regional managers, what you wouldn't want to do is within a short period of time, then come back and say, oh, wait, we actually do need another regional manager after all. You're kind of setting a lane that you're following at least for a 6 to 8 month time. And the reason that we say 6 to 8 months time, that's the 180 days, at least in North Carolina, is the time frame for an employee to file an EEOC charge. And that would be from the date of the adverse action. Keep in mind, other states are what we call deferral states. So they may have up to 300 days to file a charge. So that's why you want to get past that window of time. So if you're in a deferral state, you would want to wait even longer. You're almost going to be up to a year before, well, I guess it's 10 months before you would kind of be past that administrative charge time frame.
Thanks, Beth. All right, so we have planned our reduction in force. We have all these plans in place, and now we need to make sure that we are implementing the RIF and complying with all of our legal obligations and avoiding as many risks as we can. So ABC Inc., we are doing our involuntary reduction in force. We are reducing by about a third, and our selection criteria, we landed on a plant or location closing and performance and skill set for the other employees. And our next step is to proceed with caution and make sure that we have done everything we need to do to make sure that we're in a good place to roll this out. And so one thing to consider is the WARN Act. This is the Worker Adjustment and Retraining Notification Act. This is a federal law, and it applies to employers with 100 or more full-time employees. It requires at least 60 days notice prior to a plant closing or a mass layoff. And that notice goes to the employees or their representatives if they have a union, to a state dislocated worker unit, and to the appropriate unit of local government. And so this is why, or one of the reasons why, a reduction in force may not always happen as quickly as a company would like. There may be this notice requirement, 2 months, 60 days. There are some other scenarios that can trigger WARN Act requirements if you have sort of incremental layoffs that add up. But we are going to focus today on the definition of plant closing or mass layoff. A plant closing is defined under the statute. It's the shutdown of a single site of employment, so a single location, during a 30-day period that results in an employment loss for 50 or more employees. Then we have a mass layoff, which is a termination of 500 or more employees at a single site of employment, or 50 to 499 employees at that single site of employment if they make up at least 33% of the employer's total active workforce during that 30-day period. And so this is where it gets kind of tricky if you have a large company with several locations and you're doing a reduction in force, and you have to analyze whether the WARN Act applies to each site of employment and make sure that you have not triggered for yourself this obligation to give notice. There are some exceptions to the notice requirement. However, I will note that these exceptions are often difficult to meet. They are narrowly construed. And even if an exception applies, you may still have to give as much notice as possible, even if it's not the full 60 days. So, if you can give 50 days notice under one of these exceptions, you will likely have to do so, along with giving notice of the reason why you didn't give the full 60 days. So a faltering company the natural disaster exception, this is going to be a closing or a layoff that is the result of a natural disaster. This is going to be, the plant flooded. There was an earthquake that destroyed the office, or there is some sort of drought or storm or tornado that makes it necessary to close this location. Obviously, if that happens, 60 days notice is going to be difficult. And so that's why it's an exception to that 60-day requirement. Faltering company, that's where a company has gone out and sought new capital or some sort of new business to try to stay open. So it's faltering, it's trying, it's limping along. And giving this notice could jeopardize that new investment or that new capital. This applies only to plant closings, and it is very narrowly construed. So this one is especially difficult to meet. Unforeseeable business circumstances is the one that we sort of most often see questioned of, is this something that we can use to accept ourselves from the 60-day notice requirement? This really applies only to unforeseeable business circumstances. Oftentimes, decreasing sales are not going to be unforeseeable. It's going to be something where the biggest account suddenly terminates their contract with the company, or it's going to be something that's just sudden and dramatic and outside the employer's control. Like it could be something like a government order that stops the company from being able to operate. This is an unforeseeable circumstance that the company had no control over. But again, it's going to be narrowly construed, and it's still going to require as much notice as possible. Now, if you were supposed to give 60 days notice and you failed to do so, there are penalties, there are damages. And so you could have to provide affected employees with up to 60 calendar days of pay, including benefits, civil penalties of $500 for each day of violation for failure to notify the unit of local government, and also potentially reasonable attorney's fees if an employee or someone else brings suit. The civil penalties, I will note, can be avoided if the employer pays the employees within 3 weeks after separation. So if they provide that pay, that up to 60 days pay that they may owe to the employees, they can sort of avoid the civil penalties. But that's going to, it depends on if Warren Act applies. It depends on if you can meet any of those exceptions and how much notice you're able to give. There are also some states that have enacted their own mini Warren Acts. These expand notice requirements. So it might bring the coverage threshold down from 100 full-time employees to 75 employees like California's. But today we are not going to go into all of these states. We just wanted to flag for you that they are out there. And so especially if you're in multiple states, or if you're in one of these states that has a mini Warren Act, it's something to definitely consider and check if you're covered. Which we're going to do for ABC. So ABC, is it a covered employer? Well, it has 100 employees and they're all full-time. And so yes, ABC Inc. is going to be a covered employer. Plant closing, it is technically closing one plant. However, it's not closing a plant where it has 50 or more employees being terminated. So it's not going to be meet the definition under the Warren Act. It only has 30 employees being terminated at that plant. As far as mass layoff, we have 4 locations. It's analyzed by each single site of employment, we are terminating a total of 34 out of 100. And so none of those locations are going to have at least 50 employees. We may meet that 33%, that 1/3, but we do not meet the number of employees. So the WARN Act is not going to apply, and ABC is not going to have to give 60 days notice to all of those entities. And luckily for us, we made sure that ABC Inc. was not located in any state where it would have a mini WARN Act affect it. Now for the rest of the webinar, we're going to kind of put ABC Inc. on the back burner. Once we start talking about the discrimination analysis, which Beth is going to start off for us, it's all going to be very sort of fact specific, and we would require one of those big super mega spreadsheets for ABC Inc. that we just do not have because it's a fictional company. And so a lot of these really fact specific analyses, today we are going to sort of just talk about the legal principles and not necessarily apply them to ABC. So I'll hand it over to Beth now.
Thank you, Erin. So back, as Erin says, to the super mega spreadsheet. What we really want to see is all the data captured from about each particular existing employee, because we need to know about everybody. And then and from there you go to the selection. So spreadsheet that has, all employee by name, by department, date of hire, date of birth, because we're going to want to track age, their gender, if there are any, if there's gender and gender identity, because we also want to be able to track to see if there's adverse impact based on gender, race, ethnicity, veteran status, if you're covered under VEVRA, and then breaking it down by department and job role is a good way to do that, because you're organizing and looking at folks together when you're doing this. You also want to include in there whatever your criteria for selection. So if it's performance based, then then have a way that you are tracking and coding performance evaluations, whether it's a total point system, whether it's a 1 to 5, those sorts of things. If you have other criteria, so for instance, if it's a skill set issue, then have those skills on there. If you're transitioning into a new line of business, or you're just going through some transformational change, what are those specific characteristics and what do those employees have? Do they have specific certifications in areas? Have they shown objectively, hopefully, that they are easily learn new new areas and new job tasks? So those are all things that you want to have documented. And the reason is, document all of this ahead of time and when you're making your selection, so that you can show this is your best defense, that this has been a legitimate, non-discriminatory selection process. Then what we're going to do is go through a statistical analysis of determining whether there has been, what's the impact on protected categories. So you're going to look by, overall, and again, by category of what's the impact, by race, by gender, by, anyone who's identified as having a disability and needing an accommodation. I mean, you want to look through all, we'll look at all of that. And it's actually, and we assist a lot of clients with doing this, is running the various statistical analysis. And what we're talking about is it's an impact analysis to see what exactly, how is this from your initial round of selection before you've announced it to anybody? How is this looking? Is there, give you an example. So maybe 20% of your workforce is women, but you end up with 80% women selected. That is having an impact that could very well expose the company to a sex gender discrimination claim. So if that if the numbers come out that way, we would want to say, whoa, stop, let's reevaluate. Let's look again at what the criteria are and see if we can adjust those determination, those factors, so that we're not resulting in an adverse impact on any particular group. What we want to do is once you've landed on the right, you made the selection, you've got the right number for your budget, and we run that analysis. What we want to do, again, making sure that there is no adverse impact. And we've also got to factor in, one of those would be age discrimination. Erin, if you'll proceed to the next slide. Under the Federal Age Act Age Act statute, employees age 40 and over are protected from discrimination on the basis of age. And for those employees, to present to them any sort of documentation that contains a release of the age discrimination claim must follow what's this OWBPA, the Older Workers Benefit Protection Act requirements, which is an amendment to the Federal Age Discrimination and Employment Act. And so let me just kind of briefly go through what some of these requirements are. I'm going to do a summary, and Erin's going to get into some more details with it. So the main premise of this OWBPA, if you will, requires that employees make a knowing and voluntary release of the age discrimination claim. And in order to establish it's been knowing and voluntary, the employer has to jump through a lot of hoops. And it has to have some specific language. Unfortunately, it probably makes the agreements about 1.5 pages longer than they otherwise would be, maybe 2 pages if it's a group, because you got to give them 45 days and some more information. So it's a lot of data that you have to include. But anytime that you're, one, asking for a release of an age discrimination claim, or two, even there are even more requirements when there are 2 or more. So it's as low as 2 or more employees being offered a severance or other exit incentive in consideration for a release of claims that includes release of age discrimination.
Right. So as Beth said, I'm going to go into some of these factors in more detail. There are several factors that are analyzed to say, okay, does this release contain all the information needed for someone's release of an ADEA claim to be knowing and voluntary? And knowing and voluntary is also important for other types of claims like Title VII claims, releasing those. But we are going to really focus on these factors that are set out by OWBPA. It must be written in a manner that's clearly understood. So that is avoiding legalese, that is avoiding really technical jargon, avoiding long, complex sentences. So we try to make sure that everything's really clear and concise in this release. It also has to avoid misinformation. So this is where, part of the release is going to tell these employees the reason for the reduction in force. And so this is where you have that documented, legitimate business reason of, due to business needs, including a need to restructure and reduce costs and eliminate position redundancy, we are implementing this reduction in force. And that has to be accurate. That has to be the same reason that you decided at the very beginning. It also must specifically refer to rights or claims arising under the ADEA. So that's where a release should actually spell out the ADEA. A release that just says you release all claims, including federal claims, isn't going to be enough. You have to specifically refer to these rights. It should not include any claims that arise after the date the release is signed. So we are releasing claims up to the date the release is signed, and you have to explicitly include that in the release, that they're not giving up any claims after this date. It must advise the employee in writing to consult an attorney before accepting the agreement. And this is one where, sometimes in releases, we may see something that says, I have had time to consult with an attorney. And that's not enough. It has to actually say, you are advised to consult with an attorney. The company has to put that in the release. And so that's the type of language that we make sure is in there. It also must be supported by adequate consideration to which the employee is not already entitled. So, you are giving them money in exchange for this release, and it will recite that in the agreement. And it's going to provide the employee with time to review the agreement and time to revoke the agreement. And so this is what Beth was talking about with the 45 days. So a single employee termination for an employee who is 40 or older, they get 21 days to consider a release agreement. They also get 7 days to revoke after signing. So this is where, if you provide 21 days, we will include language in the release that tells them how many days they're given. And it'll tell them, if you decide to turn this in early, if you turn this in on day 10, you acknowledge that you've still been given the 21 days. And then there's still that 7 days after they return it. And so there's that revocation period. And so the release is going to be effective. Basically, we put the effective date as the day after that revocation period, the 8th day after returning it. If there is a group termination program, and that's going to be what's applicable here for something like a reduction in force or an exit incentive program where 2 or more employees are leaving and being asked to sign this agreement, they get 45 days to consider. Now, sometimes we get the question, well, does that mean that they're our employee for another 45 days? And the answer is no. They can be terminated, the day of the RIF, they can be terminated. After they're terminated, they just get either 21 or 45 days to consider whether they're going to sign, and then the 7 days to revoke if they want to. So they are terminated as of one date, but if they sign and return and don't revoke, they won't get paid until later. And so they won't get those severance benefits until later. But it doesn't affect how long they're employed for. We also have, I got a question in the chat. Does the 7 days take effect after the release is signed or at the end of the 21-day period? So I guess if they return it before the end of the 21-day period, once they return it, that 7 days is going to start ticking. If the 21 days ends and they return it on that 21st day, they get 7 days after. If that 21-day consideration period ends and they haven't returned the agreement signed, usually the agreement will say, okay, if you don't sign this and return it within this time period that we've given you to think about it, it's void and you're still terminated. You don't get the money, but you haven't signed this release. But the 7 days is going to be after the return of the agreement, whether it's before the 21 days is over or at the end. Sure. So OWBPA also requires, in addition to all that ADEA language that's in the release, it's also going to require a special disclosure at the end called an OWBPA disclosure. This is where we include information about the employee's rights under OWBPA. We include all that information about the reason, who was in the eligible group, what those factors were for eligibility, any time limits, such as, we looked at employees up through this date who were active employees. It'll include the job titles of all the individuals who are eligible, the ages of all the individuals who are eligible, and the ages of all individuals who were selected and whether or not they were selected. Now, this is a lot of information that goes to these employees who get these OWBPA disclosures, but importantly, it does not include the employees' names. It's just job titles, ages, and whether they were selected or not. Sometimes it could include the department too, if that's how the employees were selected or any other factors that went into the selection.
So yeah, some other considerations. One, piece of advice we've always given employers is that you make sure that you may roll out these agreements for review while someone is still employed, but you don't want them to sign it until their last day of employment or after, after the termination date, because you don't want to be in a situation where they've signed an agreement, they're still employed for 10 days, they can't waive a future claim, and they're claiming some discriminatory act took place in those last 10 days of employment. So, time the just make sure that employees are given that the final to sign version on the last day of employment or after. Other things to keep into consideration, and this really kind of goes back into that selection criteria. Make sure that you're looking at all other sorts of protected categories. Have any of the selected employees recently filed any sort of discrimination claims, any sort of internal, it doesn't have to be external, doesn't have to be just for the ESC, but, have they raised issues of discrimination or harassment, recently filed a workers' comp claim? Have they taken family and medical leave, and when, so you want to be able to track that. Do you have anybody on military leave? Other protected categories, just make sure that you're looking at all of those, because actually retaliation claims are more risky than the underlying discrimination claims. So you want to make sure that you're addressing, those situations. And let's say your worst case scenario, you have to decide to include for the reduction in force someone who is even on family medical leave. That's a really tricky situation. We definitely, recommend that you consult with counsel when going through that, as well as, these other criteria, or if somebody's on work, just filed a workers' comp claim, all of those sort of situations, because we want to avoid those retaliation claims.
Absolutely. And, we also recommend consulting with counsel about the impact that a reduction in force may have on your employee benefit plans. So whether it's a fringe benefit, like, or some sort of benefit like PTO, and, does your company have a policy of paying out accrued but unused PTO at the end of employment? And is that going to impact your costs for this reduction in force? Everything from that sort of consideration to retirement plan considerations. And of course, we would advise consulting with an experienced benefits attorney about how your reduction may impact a retirement plan, and whether it's going to be considered what's called a partial termination of a plan, which comes with obligations under ERISA and the tax code. All right, we also, as far as notifying employees go, our biggest piece of advice is to use a script, have a written script, make sure that messaging is clear and consistent. It also helps, if you have two people who are in each meeting with employees, if you're doing this, in person, or via, a virtual meeting, having two people there so that you have, documentation and you can have someone sort of back you up. It helps avoid that back and forth. Also, make sure you have a designated person for questions or follow-up. Let these employees are probably going to have questions. And so if you have a point person who has a script or has, knows the answers or knows what to say or what not to say, that could be more helpful than sort of it being a free-for-all for questions to, it might be, a lower level management versus someone who is involved with the RIF. Another consideration is just your plan to maintain or rebuild that sort of trust and relationship with the employees who are not affected by the reduction in force, because they may have questions or concerns as well. All right, finally, we have a couple of legal developments, and we've got about 5 minutes left here. And so there have been some recent changes that are affecting how we are drafting our separation agreements and releases. So our biggest piece of advice here is that if you plan on conducting a reduction in force or terminating individual employees, now is not the time to just dust off an old separation agreement and reuse it. now is the time to take a look at the language there and make sure that it is not going to be impacted and potentially make the language or the release unenforceable. So one such development is the Speak Out Act. This is affecting the language we are using in non-disclosure and non-disparagement provisions regarding disputes about sexual assault and sexual harassment. This is not going to be retroactive. The Speak Out Act applies to agreements after December 7th, 2022. So you don't really need to worry about your non-disparagement provisions before then under the Speak Out Act.
Thanks, Erin. And one thing to add on that, we did a legal alert on the Speak Out Act earlier in the year. So if you go to our website, you should be able to find that legal alert. That'll give you much more information. If you have any questions about that, just feel free to reach out to anyone on our labor and employment team. Likewise, a recent development, we also had a legal alert that went out on this last week. The National Labor Relations Board has been very active the last couple of years. We've included several updates and webinars about NLRB activity, but as late as last week, we've had two things happen. One, there was a decision by the National Labor Relations Board in February that held that an employer had violated the National Labor Relations Act by having really broad confidentiality and non-disparagement provisions in the severance agreement. In that scenario, what the NLRB itself said, we're going to hold this to be unenforceable, the release itself, because it violated the National Labor Relations Act. Then the most recent activity we've had is from the General Counsel of the National Labor Relations Board, who issues memoranda typically that set out, this is our position. If something were to happen, this is the position that we are now going to take. This guidance issued again, it was March 22nd, says pretty much that McLaren Macomb case is going to apply retroactively, and went into even more detail. So let's say, for instance, someone signed a release 6 months ago that had language that the NLRB doesn't, well, let me say 4 months ago, because there's a 6-month statute of limitations on the NLRA. So if someone, in the last several months has entered an agreement, if they filed an unfair labor practice claim based on the language in that, the NLRB may look at this, and they're going to do this analysis to see, does the non-disparagement agreement apply to, is this a non-management employee? Because only non-management employees are covered under the NLRA, whether you're union or not. The other piece they're going to look at is, first of all, they're going to pretty much not allow a non-disparagement provision unless all that you're preventing is true legal defamation, meaning maliciously untrue statements. On the confidentiality side, so when you're looking about, put a provision in there that post-employment you're agreeing to keep confidential certain proprietary trade secret information about the company itself. What the General Counsel has said is those have to be narrowly tailored. So they can't be so broad that they cover, the effect of it is to prevent employees from speaking out about unfair labor practices. So what we are really trimming down and narrowing down our non-disclosure provisions in agreements, and it doesn't even have to be a severance agreement. This could be employment agreement as well, to make sure that what we're covering is proprietary and trade secret information, not broad, operational information. And also things where you would have a legal obligation to keep confidential patient information, customer financial info, those sort of things where you've got another federal statute that requires you to keep information confidential.
And that's about out of time. We've had a few questions that we've covered in the chat box. If you have additional questions, we are always happy to advise. we are going to stop the recording and share the SHRM